back, everybody. I'm Glenn.
I'm Michael.
We are Woods and Bates, and this is Legally Speaking. I'm
What's our what's our topic today?
going to talk about lessons learned from the trainwreck trial of Johnny Depp and Amber Heard. Did you watch that one?
I saw bits and pieces of it, but I did not follow it as closely as some. I know it consumed a lot of people's lives.
Yeah, I read a little bit about it, but I think it's safe to say that their relationship was a train wreck, and that if anybody's in a relationship like that, they shouldn't be. But there's probably some things we can learn from that, I would think. So we put together the top 3 lessons that we can learn from that. And I think one of the first ones that I could see, just in the very little viewing of it that I was that, it's really important, I think, to remain in control of your emotions when you're in a trial situation, which I think Johnny Depp did a very good job of. And, the person against him really probably didn't. So what's been your experience with that in court?
One thing that I think is lost in the thought of going to trial is the judge, the jury, whoever else is in the room, the audience, they not only hear what you're saying, but they also pick up on your body language. They pick up on the tone. They pick up on the manner in which you deliver your statement. They pick up on if somebody's swiveling in their chair. I mean, as far as your credibility and being honest at a trial, I mean, somebody that's calm and is explaining themselves and the facts isn't going to be real fidgety. They're not going to have real strong emotions, but for a few different situations. But one thing that you really got to concentrate on is body language, along with whatever your statements are going to be.
And I think that, it's not going to do me any good if I get up on the witness stand and I start yelling and screaming and, making a scene. It's not going to win me any awards with the jury or with the judge, I wouldn't think.
No, and I think what we have to look at is that judge, the jury, those are all common people that are from this community. They're going to pick up on some actions that somebody may have that lead you to believe maybe they're less credible than the other person. I mean, it's you got to keep in the back of your mind, these are people that are observing you. It's not, this movie scene type of situation that everybody puts their mind in what is a trial. So, I think you really got to take a step back and say, well, these are real human beings, and how do I best pass on my message to these individuals?
I think that's important. I mean, especially in this trial that we're talking about, where credibility and the truth and veracity of what people are saying is it's what's on trial. It's a defamation lawsuit. So what they're saying is, what you said was not true. So I think
and here's the other position that I generally take is there's typically 3 sides to every story: side A, side B, and then the reality of what happened falls somewhere in the middle. And not saying that side A or side B intentionally misremembers facts, but very rarely does either side display exactly what happened to the court or to the jury.
Yeah. Well, I think that comes back to the human bias, in the situation and things like that. Not necessarily intentionally misrepresenting, but you talk about eyewitnesses and things like that. When they witness crimes, they see different things all the time. It's just kind of how it works. But I think that goes into the next thing that we can learn is, you got to be careful about what you write and say, because we certainly live in a free society. We have freedom of speech, freedom of the press, whatever, but it doesn't necessarily always mean freedom of consequence, as the parties have learned in this case.
Yeah, I think number one thing you take away from this trial is, and in any trial for that matter, or any contested situation, is anything that you put in writing digitally, it's there forever. And whenever I start a case that may go to some type of a hearing, one of the first things I tell my clients is don't put anything in writing that you wouldn't want to read in front of a judge or a jury of your peers someday. So if you want to fire off that nasty, hateful message with all the curse words in it, that's fine. But be prepared to be sitting on a witness stand someday and reading that aloud to the judge or the jury.
Yeah, they had some pretty embarrassing stuff come out, and just because I delete it from my phone doesn't mean that it's deleted forever. There's always a record of it if you write it down now.
Yeah, and bizarre thing, Apple comes out with this new software that they say you're now allowed to edit and unsend iMessages. Well, that's true to a certain extent. Maybe you send it to somebody, they don't look at their phone for an hour, and you go in and you undo that message or you delete it on your end. Well, that message there's what's called metadata, and that message can be digitally traced and digitally produced for evidence if needed. I mean, rarely does it get to that level of complexity, but whatever you put out there is going to be there forever.
And I think that that kind of goes into the next lesson, is that here in the emergency order of protection capital of the world in Logan County. I mean, you're not in Logan County right now, but I am. There's a lot of things that are written down, maybe to gain an advantage in a civil case from the get-go, that may not be necessarily true. And there's not a lot of repercussion for that. And I don't know what you see when you're litigating divorce and custody cases, but, I think that it's an important lesson that domestic violence can happen to anyone, regardless of, gender, race, whatever. It's not relegated to the stereotypical domestic violence that everyone thinks about all the time.
Yeah, I think the common thought in most people's head when they think of domestic violence is the individual that feels like a captive, that is, giving in to what the abuser wants and just kind of gets into a pattern of safety or whatever, or comfortability, whatever it may be. But whenever the reality is these toxic relationships, no one's a saint on either side. And there's likely something that would rise to the level of domestic abuse, whether it's physical or mental, on both sides. So these toxic relationships, one thing that I also think we can take away from this trial between Johnny and Amber is don't air this stuff out in court. Make every possible effort at settling this so that you don't have to air out all of your dirty laundry. And if that's not possible because you've got two very firm opinions, then sure, go to trial. But beware of the advice that we just set forth here at the beginning of this video, because it's all going to be out there and the media will pick up on it. Not just these big name celebrities does the media pick up on some of these lawsuits. So, I mean, I think you got to beware of what you do in this day and age.
I think it's very unfortunate, that there's no repercussions for people that do file things that are false. And you can see the lengths that somebody has to go to prove, if you will, that something was false. And usually there's no repercussion for that, and all that does is punish people that are legitimately in bad situations. Because it's like the boy who cried wolf. I saw the stats one time on how many orders of protection are filed in this county, and it's astronomical. But how many of those get filed as an emergency, get granted, and then get dismissed when the next hearing comes along because they weren't totally truthful in the first place? I think that's a travesty.
And the bigger travesty is the fact that an order of protection is a civil matter. So your case caption, whatever year, OP, whatever case number, that's a civil matter, and civil matters cannot be expunged. So if you get charged with a crime and you ultimately are successful in defeating that crime at trial, you get a non-guilty conviction, or you get a non-guilty ruling, you can go and you can expunge that record. No one can find that. orders of protection, even if it's not granted at the emergency level, there is a record of it within the county that says petitioner name A versus respondent name B. And a lot of people don't have the wherewithal to drill down into that case to determine, oh, this was a frivolous filing, nothing happened here. All they see is, well, this guy got an order of protection against him, or this girl got an order of protection against him. And I think that's a big flaw that our legislators need to take care of, because if we can expunge frivolous orders of protection, I think it's going to do the world a lot of good. And like you said, it's going to hopefully eliminate some of those boy who cried wolf situations.
Yeah. Or institute some penalties for frivolous filings. You know, there's penalties for frivolous filings otherwise. But I don't know. I think we've solved most of the world's problems at this point.
Yep, I think so. Because I don't know if I'll ever be able to solve the Chicago Cubs problems this year, but we'll see.
I don't know if they're worth talking about even.
Nope. Nope. Just I'd say give it about 6 or 7 weeks, and then they'll start to trade away the last few big names that they have and truly start from ground zero.
I think they'll keep the manager. I like the manager.
I like the manager. Do you see Joe Madden got canned?
No.
The Angels fired him just this week. He can come back and coach with Grandpa Ross and see what they can build up from there.
Yeah, assistant manager. That'd be sweet.
Yeah.
All right. Well, thanks for joining us, everybody. We'll see you next time.
Thank you.